Hey guys, welcome to Bilingual Classes. This is Ganesh Pujari, and in the series of video on administrative discretion, this is a second video, and in this video we are going to discuss judiciary control or judiciary review on or over administrative discretion. Now in this session we are going to discuss three important judiciary controls along with 18 case laws. Now why so many case laws? Because in this chapter you are going to get question in the form of problem, so you need to have sufficient background of the case laws. So I'm going to briefly explain each those case laws so that you can have glimpse of it and try answer your problems. With that small little introduction, let me get into the first slide. Judiciary can control or review whenever there is a failure of using the discretion, or if there is any abuse of utilization of administrative discretion, or if there is any violation of fundamental rights because of the administrative discretion. These are the three important scenarios when judiciary will control or review the administrative discretion, and we are going to understand them one by one in my future slides. The first judiciary control or review is failure to exercise the discretion by an administrative authority. Now, if any authority fails to use or exercise its discretion, then the judiciary can control or review the same under 6 different scenarios. The first one being application of mind to facts and circumstances. That means for every particular case, the administrative authority should see the facts and circumstances and then use the mind before making any discretion. In the case of Emperor versus Sibnath Banerjee, preventive detention order issued by Home Secretary without applying mind was quashed. That is the case law that you can write for this particular aspect. Secondly, acting under direction or dictation. Now, administrative authority has got the discretion and it should use independently. If it is being used by the direction or dictation, then the same is not valid, which is proven in the case of Orient Paper Mills versus Union of India, where the deputy superintendent has got the power to levy the excise, but instead of doing he himself, he has done the order done based on the order given by collector, and it was invalid because the authority of discretion is given to the deputy superintendent only. That is the second aspect. The third one is discretion by the authority itself. One who got the authority of discretion should perform. It should not be by any other authority. Fourth one, consideration of the factors of the individual cases. That is very important. For that, the case law that you can refer is Keshavan Bhaskaran versus State of Kerala, where there is a law that if people have not completed, if a children has not completed 15 years, they will not get SLC marks card. However, the authority can make the decision on case-to-case basis. Authority, instead of taking decision on case-to-case basis, they just made that anybody who is up to 13 years or more than 13 years can get the SLC marks card. That means they have just minus 2 years from 15 years. Without seeing case to case, they have made one simple rule which applicable for all the people who are above 13 years who can take the SLC marks card. It was considered as void because the power of discretion was case to case based only, not to make any rule. That is the fourth one. Fifth one is acting mechanically is not okay, which is proven as per Jagannath versus State of Orissa case, where the court held that the discretionary power were used very casually without due care and concern. That means every time while using discretion, the authority should use it very carefully and with lot of concern on that particular aspect. That is the fifth one. The last one, subdelegation, you can refer this maxim which says delegate non-protest delegate. That means a delegate cannot further delegate his function unless and until the law gives such authority. This is all about when the administrative authority fails to exercise its discretion, the judiciary will interfere with a form of control or review. With that, let's move to the second one. The second way of judiciary control or review is when abuse of misuse of discretion happens. Abuse or misuse of discretion happens, and there are 10 such opportunities. I am discussing 5 in this slide and 5 in my next slide. The first aspect is leaving out relevant events and circumstances. The discretion should be applied only for relevant events and circumstances only. In the case of Hukumchand versus Union of India, where the discretion was given to disconnect the telephone only during public emergency, whereas the authority disconnected the phone for an illegal trading. Here illegal trading was not the rule. It was only for public emergency, and hence it was considered as abuse or misuse of the discretion. The second one is exceeding the limits of power, that is ultra vires. One should not exceed the power. He should use the power according to the limits of the law only, where the case example is CS Corporation versus Workers Union. The discretion was given to award medical aid to the employees, whereas the authority extended it to family members also, which was held invalid. The third aspect is discretion based on malice or malefied. When the intention of the authority while using the discretion is not right, which is malice or malefied, the entire discretion is proven to be quashed. For example, in the case of Pratap Singh versus State of Punjab, a civil surgeon has taken leave to plan his retirement activity. While he was in leave, the leave was being revoked and they suspended him and asked him to come for an enquiry, and in the enquiry they have terminated him, and it was considered as malice intention was there, so the same was being quashed. There are two types of malice can happen: malice in fact and malice of law. The fourth aspect that we need to learn is mixed consideration. The case law for this is State of Orissa versus Vidya Bhushan, where dismissed from service for several charges, and Supreme Court held that if any one charge is valid to dismiss, in that case if the other charges are being proven or not proven is not a matter of consideration. One charge itself is sufficient to dismiss, that is under mixed consideration. And the irrelevant consideration, the case law is Asha Devi versus K. Shivraj, where a person was detained under coffee fossa and confession was made, but later the person who has made the confession retracted or withdrawn the confession, and authority has not recorded the confession whether it was been voluntarily given confession or not, and such being the case, it was considered as irrelevant consideration and the case was quashed. With that, let's moving on. The sixth aspect is different purpose other than required purpose. The administrative authority can use the discretion only for the purpose which is being mentioned. The case law for this is Nalini Mohan versus District Magistrate. The discretion was given for the rehabilitation of those persons who are being displaced from Pakistan on communal violence, whereas the authority given a rehabilitation for the person who came on medical leave. So this is a different purpose and hence it was considered as void. The seventh one is improper or colorable exercise of power, where the case law is coming from Karnataka, which is Bangalore Medical Trust versus Muddappa. The land was reserved for park, but the chief minister instructed to give that land for a private nursing home, which is a colorable exercise of power, hence it is not okay. The eighth one is violating a principle of natural justice. I have independent videos on this particular topic, the fair hearing and doctrine of bias. I have explained the SR Sharma versus State of UP, where the notice with vague allegation was not a valid notice, and under doctrine of bias R versus Bansale, where the decision was taken by 7 judges and in which 5 members were supported a cooperative society, and later it was found that all those 5 members were the member of that particular cooperative society, so they are biased. The ninth aspect is non-compliance with procedural requirement. If there is procedural requirement mentioned under the law, then those procedural requirements should be followed or they are mandatory to be followed. The last one that I am discussing on abuse or misuse of discretion is unreasonable exercise of discretion, which was discussed under Robert versus Huport case, where it was mentioned that as it may think fit when it comes to wage, but the authority understood that as he may think fit. So the court said it is not the authority which may think fit, it should be the wage which as it may think fit. That is about the abuse and misuse of discretion when the judiciary can control or review. With that, let's move to the last aspect. The administrative authority, while functioning their administrative discretion, should ensure that they are not violating any of the fundamental rights of the citizen. If there is any violation, then judiciary will control such discretion or review such discretion, for which I have brought 4 important case laws, 2 under Article 14, 1 on Article 19 and 1 on Article 21. Now, State of West Bengal versus Anwar Ali case, it was constitutional validity of West Bengal Special Courts Act, which was entitled as an act to provide for the speedier trial of certain offences, was quashed because it was harming the Article 14 of Indian Constitution. Second one, Chitralekha versus State of Mysore upheld an order of the government that defined backward class without any reference to caste, using other criteria such as occupation, income and other economic factors. Article 19, the case law that you can refer is State versus Babulal, which was a criminal case and there was no fair hearing was given, and so the court quashed the decision of the administrative authority and asked to rehear the case entirely. Article 21 is the last example that I am bringing in, that is Maneka Gandhi versus Union of India, which is the famous passport case where the passport authority tried withhold the passport of Maneka Gandhi, but the court has quashed in the case of Maneka Gandhi versus Union of India. With that, I am concluding this particular video. My next video will be on doctrine of proportionality and the doctrine of legitimate expectation, which will be the last content on administrative discretion. Now, I am trying to bring them both in a single video, but if I get too much content, I may be making two videos. Thank you so much for subscribing me. Please like, share and comment my videos. All the very best for your exams, and thank you so much for watching me.